People of Davidson County as well as the people of the state of Tennessee. Thank you for your work.
I'm hot. You're hot.
Get their money first.
We'll let Britt. Well, good afternoon. We'll welcome to the Banking Consumer Affairs Subcommittee on this beautiful Wednesday afternoon. Anytime we can get in the 70s in February, I consider that a plus. Let's see here, Mr. Clerk, will you take the roll?
Mr. Chairman, you have 5 members present. You have a quorum.
Thank you, Adam. Any personal orders here before we get started? Chairman Hale.
Two things. First of all, our chairman won't say anything about it, but how about those Lady Vols moving up? So, and the boys too. So, and after our Florida loss last night, we may be even in better shape. So, I also want to welcome a constituent of mine, a guy that works for the Secretary of State as well, but he's a county commissioner in Smith County. It's good to see Connor McDonald in the crowd today. So, thank you.
Pat, that wasn't for you. Well, a little bit of house cleaning here before we get started. Agenda number 2 today, House Bill 911 by Leader Garrett. We'll roll that for 1 week. Also, agenda number 3, House Bill 1379 by Representative Harris. We will also roll that 1 week. And we will jump right in here to our calendar here. Number 1, House Bill 1342 by Chairman Vaughn. We got a motion and a second?
Motion.
Chairman Vaughn, you're recognized.
Thank you, Mr. Chairman. And boy, you folks that showed up today are about to get your money's worth. We're going to move public policy in a positive manner for all Tennesseans with this bill. It comes from the Secretary of State's office. In 2017, we created an expedited process for public officials to challenge bogus UCC liens filed against an official. And these usually come from sovereign citizens or somebody with malice in their heart that's trying to screw up somebody else's finances. It's something that's been done that's aggravated them. This is the way that they take out their form of protest, and they file these bogus UCC liens and mess up someone's credit. So what this bill does is 2 things to help streamline an expedited process. First, it says the filing office that has the information about the challenge UCC lien can and will send specific documents about the lien to an administrative law judge so that that law judge has the necessary documents for the hearing. And then secondly, the bill provides that the party that prevails in the expedited hearing will notify the filing office of the outcome of the dispute so the filing office knows what steps it should take to whether it's to dissolve the UCC or reinstate it. And so that's what we're doing. I appreciate the Secretary of State for expediting the process and making it to where we can have these narrative wells taken care of and people, the impact of narrative wells actions on them, have it remedied in a faster manner. So with that, Mr. Chairman, I'll answer any questions people have.
Thank you, Chairman Vaughn. Any discussion on the bill? We got a question called on the bill. We're ready to vote. Mr. Clerk, please open up the vote. All those in favor of House Bill 1342 moving on to commerce, vote aye. Those opposed, vote no.
Mr. Chairman, you have 7 ayes and 0 noes.
Thank you, Mr. Clerk. The ayes have it. House Bill 1342 will go on to commerce. Chairman Vaughn.
Mr. Chairman, I miss saying "I" so much. I don't know about my fellow colleagues. Is it okay if I press the green button and say "I" at the same time? Would that be a break? Is
Most
that against the
definitely.
rules?
No, sir,
All
not
right.
at
I
all.
always feel like I hadn't gotten my money's worth unless I vote out loud. All right, that's what I'm gonna start doing. Might be free.
All right. Let's see here. Number 4. Yep. Moving on to House Bill 1384 by Representative Harris. Second. Representative Harris, please discuss your bill.
All right, thank you, Chairman, and thank you, Committee. House Bill 1384 is called the Pay Stub Protection Act. Tennessee is one of only 6 states currently with no pay stub requirements. And so what this bill would do would make it to where your employer would have to be able to provide you some form of pay stub. And part of doing this helps prevent wage theft. A pay stub is really needed in a lot of different ways, to renting an apartment or qualifying for a mortgage, to qualifying for credit such as an auto loan, and to confirm that they are classified as an employee and not misclassified as a contractor. So there's a lot of reasons why pay stubs are important. And so I hope that this committee would accept this bill and move it forward to the next one.
Thank you, Representative. Any discussion on the bill? Representative Lynn.
Thank you. I really agree with the premise, but is electronic form of a pay stub acceptable in this bill? A lot of employers, such as the one I work for, their employees are not in the same town. They are, way far away, and it would be very difficult for us to get that to them, and very expensive. Right now, we do supply an electronic pay stub, and I just want to know if that meets the requirement.
Representative Harris.
Thank you, Chairman. And yes, that it absolutely is something that is within this bill. So you have that full range. As long as we are providing some form of pay stub, it does not limit how they do that.
Representative Hemmer.
Thank you, Mr. Chairman. The sponsor just answered my question, but just want to thank him. I think it's a great bill that will definitely help prevent wage theft. And I was surprised to learn that we are one of the few states that don't have this. So thank you for bringing this.
Yes, thank you.
Chairman Vaughn.
Yeah. Thank you, Mr. Chairman and sponsor. I've told you this before. I appreciate you bringing this because it's something that I was unaware of. And when I think about the fact that the transparency of a relationship between an employer and an employee, it all comes home to roost on that paycheck. And if there's ever a discrepancy between what's, employee morale, getting shorted on a check is one of the worst things ever. And so having somebody be able to verify and document that they are being paid appropriately, and then you touched on in your presentation, being able to alert someone that they are maybe a 1099 contractor and there's no withholding being taken out of their check. And it also holds employers responsible for collecting those withholding taxes and getting them paid. And so, again, I'm surprised that this was not in there, and it's good for you for finding it and good for you for fixing it.
Thank you, Chairman Vaughn. Representative Lynn.
That's an excellent point about the 1099 contractors. In this bill, are they considered employees? Generally, they will submit a bill or, so they have the remittance when their money goes in their account electronically. Generally, there is some sort of remittance that a system might email to them, but it's not really a pay stub. So do 1099 contractors count?
Representative Harris.
Thank you, Chairman. And yes, the 1099 contractors do count because the definition for employee means just a natural person who performs a service. So whether they are performing a service as a 1099 contractor or as a W-2 employee with you, then either way, they are still considered an employee by you.
Okay.
Representative Lynn.
And then another follow-up question. A lot of LLCs perform services, say, on your property, and therefore you need a certificate of insurance from them. And if they're an LLC, you have to provide them with a 1099. So they're not necessarily an employee. They're kind of billing you. I can think of our accountant. Our accountant sends us bills. At the end of the year, we give her a 1099 for all of the work that she's done. She sends a bill to us and we pay that bill. So in the event someone sends a bill, would that be suitable? Because they've actually billed you. You're not necessarily deciding that's how much I'm going to pay them. I can think of other folks we might have working for us, who mow. They come and mow, and it's by the job. So it's not necessarily, where do you split that between who is the 1099 contractor and you need to provide them with a pay stub, and who is that 1099 contractor who's, they're a business, and would it be sole proprietors or something like that? Where does that split come in? Representative Harris.
Thank you, Chairman. And so I'm going to say, based on the language, because I've went through this a few different times, that would be considered a vendor and not necessarily someone who is an employee, because in point 4, it says work week, which means a fixed, regular, recurring period of 168 hours. And so that person is technically not doing a service that would be considered fixed for a work week. They are doing more vendor work. And I would label that as vendor work. I wouldn't consider that person a specific employee or a specific contractor. That sounds like a vendor.
Per IRS regulations, if someone is working for you and they're not, quote, your employee, but their work is directed by you, the person who's going to be paying them, they are not legally a 1099 worker. They are an employee, and you have to make them an employee. So I wonder, maybe if we vote for this, maybe between now and full committee, we can just look into that a little bit and just provide some clarification so that everybody knows who they should give a pay stub to, who is not necessarily an employee. You're paying them directly.
Representative Harris.
Thank you, Chairman. And that's a good question. And I'll definitely make sure we follow up on that one as well.
Speaker Marsh.
Thank you, Mr. Chairman. And I didn't know we had this problem in Tennessee. I could see it could be a problem if people don't offer one. My question would be, do you have to give them the stub at the time you pay them, or just make the stub or the records available? And the reason I asked that, I was at breakfast with some of my buddies this past week, and one of them is a contractor, and one of his workers came in and said, I need my check. And it was Friday, it was payday. So he handed him a check, and I'm sure he had the deductions and all that taken out, but he didn't give him a stub. But I would think it would be okay if the guy wanted a stub, he could give him one, but he doesn't have to necessarily provide one at the time the check is given out. I just want to see if that's a mandate that you've got to have a stub when you give them the check.
Representative Harris.
Thank you, Chairman. And that is correct. So they do not have to provide it at the exact time. What it says is an employee who does not receive a statement as required, typically by subsection C, may make a written request, including electronically, to the employer or employee for them to receive a paycheck stub within 10 days of that request.
Gotcha.
So they have time to provide that.
Good. Thank you.
Chairman Vaughn.
Thank you, Mr. Chairman. And to Representative Lynn, I would think that in the difference in that where the sponsor mentioned vendors, I would think I have a hard time issuing 1099s to somebody that I didn't get a invoice from, a check. And so I think that's, if you have an invoice, then there's, for services, bill for services, that maintains that contractor relationship. And so that kind of takes it out of this realm. I think that what we're talking about here is wages. And the reason I say that it helps distinguish between that is somebody, they'll at least know that they're having withholding taken out. And that's a point of contention that, hey, am I a W-2 employee or am I a 1099 employee? This solves that in the same way with Speaker Marsh's question. It's just, this bill is saying that people have got to keep up with this. so that employees know, and it's just a good accounting practice in general. But like I said, one issue that I do have that I want the committee to know that I'm willing to vote favorably for this and move it on to the to full committee, but I want y'all to be aware of a question that I have about it that I want to get resolved before full committee. And if y'all be okay with maybe seeing an amendment in full committee, and that is, I've talked with the bill sponsor about it, and that's whether the enforcement arm of this should be under Department of Labor or under Commerce and Insurance. And because when I think about it, more than likely Commerce and Insurance represents the employer. You know, they deal with the employer more, but labor works with employee. But then when I start thinking about the functions of the two departments within the state, as far as collection of fees in the case of malfeasance, or like I know Commerce and Insurance covers things like licenses for professionals and contractors. They have it seems to me like they probably have a better built-in enforcement arm or a system by which to issue these penalties if somebody just drags around and refuses to comply. And so that's what I'm going to be looking into between now and next week. And if y'all are okay with that, rather than us rolling this today, just to keep things moving, that would be what I would be proposing in an amendment if it does turn out that Commerce and Insurance is a better department under which to enforce this. I checked with the Attorney General's office and they said that they didn't feel like they would be the appropriate group. So that I just wanted y'all to be aware.
Chairman Vaughn, thank you for the great point there. Any other discussion? I think we're ready to vote. Mr. Clerk, please open up the vote. All those in favor of HB 1384, moving on to Commerce, vote aye.
Aye.
Those opposed, vote no.
Mr. Chairman, you have 7 ayes and 0 noes.
Thank you, Mr. Clerk. House Bill 1384 goes on to Commerce.
Thank you, Mr. Chairman, and thank you, committee.
Let's see here. Well, that pretty much wraps up our bills that we have today, but now we've got an avalanche of knowledge that's fixed to be presented to us by Mr. Troy Haley, a legislative liaison with the Bureau of Workers' Compensation. But first, let's go out of session. A little bit of the bio here while he's getting buckled in there. On July the 1st, 2022, Governor Bill Lee appointed Troy Haley to be the administrator of the Tennessee Bureau of Workers' Compensation. He has been with the Bureau since 2007 in various roles, including mediator, hearing officer, legal director, and legislative liaison. He is a native of Inglewood, East Nashville, and received his undergraduate degree from David Lipscomb College, master's degree from Tennessee State University, and law degree from the University of Memphis. He has been licensed to practice law in Tennessee since 1992 and has been a Rule 31 mediator since 2008. Mr. Haley, glad to have you here.
Good to be here. Thank you for having me. I'm Troy Haley, Administrator of the Bureau, and I'm pleased to have with me today Amanda Terry. She is the current legislative liaison for the Bureau and the director of our legal services. So I'm glad that she's here with me today. And I've got a few slides. I'll go through these fairly quickly. If there's any questions, certainly stop me. But this is just kind of a work comp overview and an overview of what the Bureau of Workers' Compensation does here in Tennessee. So first of all, what is workers' comp? Well, it's not unemployment. There is some confusion there. Workers' comp is for on-the-job injuries. That it could include a mental injury. It's not like unemployment. We don't pay the benefits. Those benefits are paid by the workers' comp insurance carrier or the self-insured employer. Generally, workers' comp provides wage replacement and medical benefits to employees who get hurt at work. The trade-off, the injured worker gets their benefits, but they do relinquish the right to sue their employer in tort for negligence or pain and suffering, punitive damages. Sometimes hear that referred to as a grand bargain or great compromise. Generally speaking, workers' comp is state law. It's not federal. We got 50 states and they all have their own unique systems. Alabama is the only state that does not have an administrative workers' comp court system. All the other states do. In Alabama, you still go to circuit or chancery, whatever it's called there in Alabama. But we were the 49th state in 2013 to establish an administrative system. Several of you were involved in that reform 10 plus years ago. And so we are the 49th state to have a workers' comp administrative system. What you get if you're injured on the job is temporary disability benefits, 2/3 of your average weekly wage. That's not taxed. If you're off work, you also get your medical treatment provided by the authorized treating physician. If you got a permanent impairment rating, you also get permanent disability benefit, depending on what the rating is. And then there's also death benefits and burial expenses, unfortunately, in those situations where there's a work-related death. Probably the three most common questions that I get asked if I get a call from one of your offices or a constituent that workers' comp won't pay my benefits or won't provide my medical treatment, what they're saying is that the employer has denied the claim either on compensability or some other issue. Sometimes medical treatment gets denied based on medical necessity under a utilization review. If they can't find a lawyer, we get that complaint a lot. We do have ombudsmen that can help. They cannot provide legal representation at any point in the legal process, but they can help answer questions. We've got 4 ombudsmen. We're about to hire another one. We've got 3 more ombudsmen who are attorneys that can give limited legal advice, and we have an opinion from the Board of Professional Responsibility that would allow those attorneys to give certain limited legal advice. It's kind of a list of shalls and shall nots. But that's an issue. And then state employee claims, we'll be happy to help get you to who you need to go to there. But I know I get quite a few questions about state employee claims. So we don't have any jurisdiction over those. Those are under the Treasury Department Claims Commission. The state is self-insured. And there's the statute that shows that the state is excluded from the Tennessee Workers' Compensation Law, along with counties and municipalities, but they can opt in if they like. They can file a notice with the Bureau and opt in and purchase a work comp policy. Some have, many have not. Those who have not are either self-insured or they have some sort of on-the-job injury type plan to take care of workers who are injured on the job, but it's a separate process. It all started in Tennessee in 1919 with Public Chapter 123. Surprisingly, there are several elements in that original bill that are still in the law today. It's changed a lot over the years. In 1917, we saw a movement and some comments made by Tennessee Governor Thomas Clark Rye, who recognized that with industrial development, manufacturing, hazardous machinery, we needed to take care of the injured worker and we needed to set up a system that was fair to both sides. And that's what we tried to continue to do all these years. In Tennessee, unfortunately, around that time preceding the Workers' Comp Act, there were a couple of really bad mining disasters. Frederickville mining disaster, that's in Anderson County, 216 miners died. Worst mining disaster in U.S. history. Cross Mountain, Briceville, that's Anderson County. 89 miners died. That was in 1911. And then the Triangle Shirtwaist Factory fire, that was probably the triggering event across the country that led to most states enacting a workers' compensation system. That was a terrible situation where 146 workers died and most of those were women and girls are between the ages of 14 and 23. That is the site of the Triangle Shirtwaist Fire. Those top 3 floors there were engulfed in flames, and the victims could not get out. That building is still there. It's on the campus of New York University, very near Washington Square Park. If you've ever been there, there's a historical marker there. In 2013, the major reform that has happened in the 100 plus years of workers' compensation in Tennessee occurred. As several of you remember, there was an administrative court system established, and the standard changed to where the injury had to primarily arise out of in the course and scope of employment. Previous to that, it was a remedial statute, could be from a doctor, plus lay testimony, which could be from the injured worker, was sufficient. But now it's a primarily standard according to the authorized treating physician. The statute there that I included sets out the Bureau of Workers' Compensation as an autonomous unit attached to Labor and Workforce Development for administrative matters only, such as budget. Previous to 2013, we were involved, obviously, under the Department of Labor and Workforce Development as the Division of Workers' Compensation. So the agency's been around a long time, but it was separated primarily because of the autonomy of the court system. What do? We cover a lot of territory. I would want to point out that the mediation and ombudsman service is usually the first contact that folks have with the Bureau. We have ombudsmen who answer questions and try to help folks get on the right path as far as their workers' comp claim. If they can't get it worked out, the parties can file a petition for benefit determination with the Bureau, and a mediator gets assigned. The mediator usually about 4 times out of 5, 80% of the time, usually gets it worked out. But we do have a Court of Workers Comp Claims and an appeals board. I want to point out that our Next Step program is a college tuition for injured workers who can't go back to doing what they did pre-injury. So that's been a good success. The Certified Physician Program, I got an email yesterday. We've hit 100 doctors now that we have trained in best practices on workers' compensation. They are now certified physicians with the Bureau, and they get paid a little extra on the office visits and on the impairment rating. It's helping a lot with the access to care issue that we have in Tennessee. And that reward program is, we've gone around the state speaking with employers to try to educate best practices on handling a work comp claim, how to bring employees back to work, because, getting them back to work is really the best thing for everybody, for the employer and the injured worker. We have, 7 offices in Tennessee. We used to have an office in Cookeville, but we had to give that one up during COVID. We still have a judge there who hears cases in the old Putnam County Courthouse, but we have an office in Memphis, Jackson, Nashville, Murfreesboro, which is a super busy office, Chattanooga, Knoxville, and Gray, Johnson City, Tennessee. We have courtrooms and mediation offices in all of those locations. There are our judges. We are missing Judge Durham in Cookeville. He didn't get the memo and didn't show up for the photo, but we have 12 trial judges across the state. In front with the center seated in the glasses is Chief Judge Ken Switzer, who's been the chief judge since the court's inception. Workers' Comp Appeals Board hears all of the appeals. The appeals board judges are appointed by the governor. The trial level judges are appointed by the administrator. I would point out here that presiding Judge Tim Connor in the middle is not that short. The other 2 judges are just super tall. Judge Godkin on the left played volleyball in college, and they're just really a smart, dynamic group, but Judge Connor, he's really not that short. By the numbers, we'll send out an annual report in April that'll have all the 2024 numbers. They look substantially similar. I didn't see anything major change-wise, but around 90,000 work injuries a year is what we're seeing. Is down from about 100,000 years ago when I first started doing this. Unfortunately, there were 79 work injuries last year that resulted in fatalities. We had over 3,500 petitions, lawsuits filed with the Bureau, but about 2,400 of those were resolved in full or in part by the mediator without having to go to court for a trial. The court approved over 8,500 settlements, and our ombudsman program assisted almost 15,000 injured workers and their employers. This is probably too small to see, but I like the way this slide looked because of the colors and everything. But it's injuries are kind of evenly distributed by age, from early age to middle to older workers. And then as far as the injuries by county, the major counties, population-wise, had the most injuries, as you might expect. Nothing earth-shattering here. Some of the key indicators of the effects of the workers' comp reforms, the number of weeks from the date of injury to the date the injured worker reaches the end of their medical treatment is decreased from 60 to 39 weeks, pre-reform to post-reform. The average number of weeks from maximum medical improvement, which is when the medical treatment ends, to the conclusion of the claim is decreased from 50 weeks to 26 weeks. The percentage of workers who return to work, that's a key indicator and very important, 61% pre-reform to 72 post-reform. And I just threw this in at the end. We've got 145-ish employees in those 7 offices. We had 30 or more, around 175 pre-reform. So we're doing more work with fewer people. And to leave you with this, if you keep up with, the business media and workers' compensation news, the Department of Commerce and Insurance recently announced that workers' comp loss cost decreased for the 12th consecutive year since the reforms went into effect. And that's one of the elements that goes into the calculation of workers' comp premium. So I think employers have been pleased with the results of the reform. And I think hopefully injured workers are getting treatment faster and getting better and getting back to work. There's our glamour shots. And there's our contact information. And if you ever have any constituent issues, you obviously know where to find me and Amanda. And we certainly would yield to any questions the committee might have.
Thank you, Mr. Haley and Ms. Terry. Ms. Terry, thank y'all for being here today. Any discussion here with our panelists? Yes, sir, Speaker Marsh.
Thank you, Mr. Chairman. And I was here when we went through all of that with you, Troy, and you did an excellent job with that. And I think what we've done, we made it where Tennessee's a lot more business friendly and a lot more industry and companies have moved here because of our good work comp laws here. So I appreciate you doing that and continue to help out. Thank you.
Thank you.
Thank you, Speaker.
Yeah, thank you.
I got a question here.
Sure.
On your next step program, how many injured employees have you helped with that?
We've helped over 100, maybe in the 120 range, I think. We don't have that many on scholarship, though. On scholarship, that exact number escapes me. It's 20 something or 30 something that we've had since the inception of the program. But our Marion White, the program coordinator over that, she goes out to American Job Centers and meets these folks and tries to help them with, their resume and, tries to help find them work if they're trying to get back to work. and helps them with the application process. So it's been a good success. And even those that we haven't actually given a scholarship to, I think we've provided some help to them in other directions too.
Well, thank you. Any more questions? Nope. Representative Hemmer.
Thank you, Mr. Chairman. Thank you for the presentation. If you wouldn't mind, go back to the slide to the 2023 numbers. I think it's the first one that had talked about the 90. Yes, sir. I'm just trying to decipher through that. I see the 91,000 injured and the 8,500 supplements, but how many workers' comp claims were filed?
So the 3,500 petitions for benefit determinations, those were that's the number of lawsuits that were filed. But the contacts, the 14,797, that's the number of folks who have reached out because they've got a dispute with their employer, or the employer's got a question about whether work comp benefits are due. So we're getting around 15,000 inquiries, but what's not really shown on this slide is those 14,797 that contacted an ombudsman, 10 or 11,000 of those got worked out because of the work of the ombudsman. They reached out to the employer, they reached out to the insurance claims adjuster, and got the minds together and got it worked out before a PBD, a lawsuit, had to be filed.
Representative Hemmer.
Just from my understanding, so if a worker gets injured, are they typically contacting the ombudsman?
It's hard to say, yeah.
But on their own, or is it through their attorney, or how does the process work today?
Generally, if someone is injured on the job, they report the injury within 15 days to their employer. The employer provides, or the employer's insurance agent provides a panel of physicians, 3 or more doctors to choose from. The choice is made, appointments made, they go to the doctor, get treatment. If they're off work for more than 7 days, they get their lost wages, they get back to work. Most of the time it works smoothly, just like that. But if there is a dispute, that's when the parties reach out to us to try to help. We're the ombudsman and mediators in court. We're not the folks that pay the benefits. We just try to help get things worked out so that they don't end up in front of a workers' comp judge.
Representative Hemmer.
Thank you. Last question. Thank you for that explanation. Just curious how I see the numbers of the resolutions and whatnot, but I'm just curious how we match up per capita compared to other southeastern states.
Other than Alabama, I think it's fairly consistent across the Southeast. As far as work injuries go, that seems to be directly corollary to the population and the number of workers that are actually out there doing construction work, manufacturing work. We have a lot of industry here in Tennessee. I think we're going to see an uptick in those injuries once the 2024 numbers are finalized. The 79 work fatalities, that's up in 2024, up over 100. That number I already know. So that's unfortunate, but there's just so much work that is going on in Tennessee, so much construction work, automobile accidents that are work related. But from state to state, it does vary. But again, other than Alabama, which I don't really have a good feel of how they do things, the feedback, yeah, the feedback I get from other states is that it's substantially similar to ours, but with all the construction and business manufacturing that we have here, it would be expected that it would be slightly higher here.
Speaker Marsh.
Thank you, Mr. Chairman. And I'd like to ask, how do you get your funding? Is there a charge for work comp insurance through the insurance companies that pay you all?
We're state funded. There is a work comp insurance premium tax, and some of that money does go to the state to help facilitate the workers' comp program. Some of that money goes into this, what used to be called the second injury fund, subsequent injury fund now, and that's the money that we pay the next step scholarships from as well. So, right, it's a fully state program that we don't get any federal money at all. We got a little bit of that ARPA money for some tech IT stuff during the pandemic, but that's all gone now. So,
Do you get enough money to sustain your department?
we could always use more, but
That's not what I asked.
no.
And
we
did you
do.
make any lawyers mad in 2013 when the law changed?
Well, you're correct about that. I think we've seen a decrease because of the stability of the system and the predictability of it. There's just not as much, unless it's a serious injury, there's just not as much to argue about. And the recoveries are not as significant as they were pre-injury. So we're seeing fewer plaintiffs' lawyers involved. That's one of the main reasons we've got the ombudsman attorney program. But Chairman March, you mentioned trying to bring businesses to Tennessee and keep them here. And that was one of the main reasons of the reforms in 2013, because we were, our system was not as efficient as it is now post-reform, and the changes needed to be made. And I think it's been positive.
Everybody's heart's clear. Well, Mr. Haley and Ms. Terry, thank y'all so much for your presence and appreciate what y'all do for the state of Tennessee.
Thank you.
We'll go back into session. Just to gavel out. Meeting adjourned.